Well, it's good to speak to the hardy souls who've lasted through to the end. May I begin by thanking the Institut d'études avancées de Paris, Itzhak Fried, Alain Berthoz, Simon Luc, and Grady Myrdal, and the other organizers for their kind invitation to participate in this conference on how the transformation of groups of previously nonviolent individuals into repetitive killers of defenseless members of society occurs. Now, the law has its own concepts and vocabulary, but it has always had an important interface with science, with medical science and social science. In my own career as a lawyer and a prosecutor, I've dealt at various times with issues of forensic pathology, forensic anthropology, forensic psychiatry, psychology of eyewitness identification, linguistics, political sociology, contemporary history, and so on. And I'll come back briefly to neuroscience and syndrome at the close of my talk. What has been the response of international criminal justice to this phenomenon that we've been discussing, this matter of the transformation of groups of previously non-violent individuals into repetitive killers? I suppose the modern response can be traced back to the Nuremberg and Tokyo trials that followed upon the Second World War. Much more recently, mass atrocities committed during regional conflicts led the United Nations Security Council to create the International Criminal Tribunal for the former Yugoslavia, or ICTY, and the International Criminal Tribunal for Rwanda, or ICTR, and also the Mixed National International Special Court for Sierra Leone. Now, these institutions were all temporary in nature and fashioned as responses to specific situations in which the phenomenon that's been the subject of discussion here had occurred. In 1998, the Treaty of Rome came into being for the establishment of a permanent international criminal court. The ICC became a reality in 2002 with the ratification of the treaty by a sufficient number of states parties, and its jurisdiction over war crimes, crimes against humanity, and genocide committed on the territory of a state party or by nationals of a state party dates from the 1st of July 2002 onward. The ICC became truly operational in 2004. I'm going to speak briefly this afternoon about the central concern of international criminal justice, the focus of investigations and prosecutions, and the concepts of responsibility and punishment before summing up with a very brief conclusion. The central concern of international criminal justice is war crimes, crimes against humanity and genocide. These crimes shock the conscience of humanity and threaten the peace, security, and well-being of the world. And so they are a concern of the international community as a whole. The framers of the Rome Statute of the International Criminal Court intended that such crimes should not go unpunished. International criminal law represents an affirmation of the principle of individual moral responsibility and thus accountability for actions. The effective prosecution of war crimes, crimes against humanity, and genocide is meant to contribute to the prevention of these unimaginable atrocities. The condemnation of the perpetrators of mass atrocities thus aims to prevent the commission of these crimes. So in sum, the concern of international criminal justice is to punish those responsible for mass atrocity crimes and so to deter the commission of such acts. The general tendency of those applying international criminal justice has been to focus upon individuals in positions of power and influence who are the most responsible for the perpetration of mass atrocity crimes. Now, while particularly notorious or cruel offenders have attracted prosecution, the focus has not generally been upon ordinary individuals who have undergone such an extreme change in behaviors to become repetitive killers in groups. Rather, the focus has been on those who help create the conditions for such transformations to occur, or who direct the actions of the groups, or who participate in a leadership role in the perpetration of atrocities. So, for example, at ICTY, Milosevic was prosecuted for directing the campaign of terror designed to drive out the Kosovar Albanians from Kosovo. But the man alleged to have thrown a grenade into a basement crowded with women and children in Prizren was not. Those ordinary individuals have usually been left to national or local authorities to deal with if they have the capacity to do so. This choice of whom to prosecute is in part a function of the resources that states make available to international criminal tribunals or courts. It's also, however, a reflection of the desire to hold the powerful to account, since the powerful have in the past enjoyed impunity, should I say, for their crimes. Prosecuting those most responsible for mass atrocity crimes, it's hoped, will generate the greatest deterrent effect. Cases brought before the UN International Criminal Tribunals or special courts have tended to focus upon political and military leaders who are alleged to have used their power and influence to get others to perpetrate violence. Occasionally, as I noted earlier, direct perpetrators of crimes who are particularly notorious, for example, Jelicic, who styled himself the Serb Adolf Hitler and personally shot to death a number of Bosnian Muslims, have been brought to justice before an international criminal tribunal. The same general approach I've just outlined is the approach we tend to take at the International Criminal Court. The concepts of responsibility and punishment under international criminal law derive from the traditions of the law and sentencing philosophy. And these concepts are expressed in terms that are quite different from those employed in neuroscience. I've been fascinated by the presentations that were made over the past 2 days, but I can assure Itzhak that I have been quite outside my comfort zone in terms of the language and the concepts that were being expressed, although I could often see where the interface might come. The law uses language that speaks in terms of moral accountability and the denunciation and deterrence of crime. In order to assess criminal responsibility, the law analyzes the conduct of an accused as a function of the intent or mental element of crime on the one hand, and the act or material element of crime on the other. At trial, of course, the accused is presumed to be innocent of any evil intent or act until the prosecution proves the contrary to the satisfaction of the court beyond reasonable doubt. The prosecution has the burden of proving both the mental element and the material element of the crime charged. So to take an example, under the Rome Statute of the ICC, for an accused to be found guilty of murder as a crime against humanity, the prosecution will have to prove the material and mental elements of the crime, namely, that the accused caused the death of one or more persons, meaning to cause death, or being aware that death would occur in the ordinary course of events. This conduct was committed as part of a widespread or systematic attack directed against a civilian population, and the accused knew that the conduct was part of, or intended the conduct to be part of, a widespread or systematic attack against a civilian population. An attack directed against a civilian population is understood to mean a course of conduct involving the multiple commission of acts, such as murder, against a civilian population, pursuant to or in furtherance of a state or organizational policy to commit such an attack. Now, the attack need not be a military attack. The notion of policy requires that the state or organization actively promote or encourage such an attack against a civilian population. The individual criminal responsibility for the crime does not require proof that the accused had knowledge of all of the characteristics of the attack or the precise details of the plan or policy of the state or organization. So that just summarizes all the features of the crime of murder as a crime against humanity. Now, murder in domestic criminal law systems may only require proof that the perpetrator caused the death of a human being, meaning to cause death, or meaning to inflict bodily harm that the perpetrator knew was likely to cause death, but was reckless whether death ensued or not. Proof of all of the additional features of the crime of murder that I mentioned earlier raises the crime to the level of an international crime, not just the murder of an individual, but murder as a crime against humanity. Without the connection to a widespread or systematic attack against a civilian population, the murder remains the ordinary crime of murder to be punished under domestic criminal law. Proof of murder as a crime against humanity requires proof of a connection respecting both material and mental elements of the crime with a much wider context of violence. Given that this conference has focused upon the science of the brain, my focus here will be intent, or the mental or moral element of crime. So in the example I've chosen, the mental element of the crime encompasses the intent to kill and the intent for the homicidal act to form part of a widespread or systematic attack against a civilian population, or the knowledge that it does. Generally speaking, under the ICC statute, a person has the requisite intent with respect to the material elements of the crime if he or she means to engage in the conduct charged, or means the consequence charged, or is aware that it will occur in the ordinary course of events. Now, the law draws an important distinction between intent and motive. Motive is what may lie behind the acts and intent of the perpetrator of a crime, but as a concept, it is distinct from the intent that the prosecution must prove. Evidence of motive is, of course, relevant, and it may help prove intent. Proof of intent tends to be a matter of inference, unless it is a rare case where the words uttered by the accused clearly reveal his or her intent. So the prosecution will seek to prove the intent or knowledge of the accused on the basis of the conduct of the accused, any words he or she may have uttered, and the circumstances and context in which he or she acted. This is all circumstantial evidence which can support an inference of intent. Thus, the conceptual language of the law, when it speaks of responsibility, is very different from that employed in neuroscience. The law does not, one might suggest, delve as deeply into what makes the brain pull the trigger or swing the machete. There tends not to be a great subtlety in the analysis of the mental element of crime. It's enough to connect to an unlawful act the desire to bring about the consequence of the act, or knowledge that this consequence will occur in the ordinary course of events. So if we think of the photograph that Itzhak put in his report, and I believe we saw at the very beginning of the conference, the photograph of the German soldier aiming his rifle. It's a fair inference that the soldier pictured in the photograph knows that aiming his rifle and shooting a bullet into the head of another human being will cause her death. Moreover, circumstances could be established to support the inference that the soldier knew that what he was doing related to a program of extermination of a civilian population, and that this was occurring in a widespread and systematic way as part of a state policy. Thus, we have the very image of the crime of murder as a crime against humanity being committed. Now, when I come to the question of punishment for such crimes, I'll deal further with this concept of moral responsibility. But I did want to note that international criminal laws, in the case of domestic criminal law, does allow for defenses relating to intent or state of mind that have the potential to exclude criminal responsibility. For example, under the Rome Statute, mental disease or defect that destroys a person's capacity to appreciate the unlawfulness or nature of his or her conduct, or capacity to control his or her conduct to conform to the requirements of law, is a ground for excluding individual criminal responsibility. Such a defense may negate the mental element of crime. This only goes to underscore the importance of the concept of moral responsibility in criminal law. A person incapable of appreciating the unlawfulness of his or her conduct because of mental disease or defect will not be held to account in the same way as will another person who does not so suffer. So how the provisions of the Rome Statute will be construed in practice remains to be seen. It may be that they will be narrowly applied so that many individuals who have been conditioned to become killers, for example, by relentless propaganda, will not be absolved of criminal culpability for their actions as repetitive killers in groups. In Rwanda in 1994, a situation with which I became familiar, what caused people to become killers? What caused those who engineered the genocide to do so? The factors, it has been suggested, were many and varied. For those on the ground who did the killing, the causes were multiple. Hatred, generated by propaganda that dehumanized their victims. Fear of the enemy attacking force that was identified with the ethnicity of their victims. A desire to profit, obedience to authority, fear of consequences for not participating, liberation from the normal moral constraints of society, sheer bloody-mindedness, and so on. The books that the French journalist Jean Itzhak wrote on the 1994 genocide in Rwanda, based on his interviews of survivors and killers, are worth reading for anyone considering Syndrome E. In his book, Une saison de machette, Itzhak quotes one killer he interviewed as saying he remembered the first man he killed very clearly. But for others, it was blurred. When committing those murders, he had not even perceived that small thing, cette petite chose, that was going to change him into a killer. Not everyone did go along with the killing in Rwanda. This too is a phenomenon, I think we've already noted, worthy of study. There were many astonishing acts of courage and compassion by individuals who saved their neighbors' lives. Now, what causes some individuals to swim against the current of events? As for what motivated those in positions of power and responsibility, who were the principal targets of prosecution at the Ictr, the causes were multiple too. Fanatical hatred, determination to cling to power, fear of the other, competition for limited resources, inability to resist going along with the extremists, opportunism, careerism, and so on. All of these factors were part of the contextual proof of genocide and sometimes also evidence of motive going to proof of intent and knowledge on the part of individual accused. We're still, however, not speaking in terms that neuroscientists might use, but in terms actually very ordinary, everyday terms that the law uses. It's interesting to note that the accused denied responsibility for the crimes they were charged with, and they gave very little insight into what was in their minds or what their intentions were. In fact, they tried to show that they did the opposite of what they were charged in the face of the evidence. So to sum up on responsibility, a person who commits a criminal act, that is, commits the material element or elements of the crime with the requisite intent or knowledge, is criminally responsible for that act and liable to the consequences that the law reserves for such conduct. The law also approaches punishment for crimes in moral terms. Put simply, perpetrators of evil deserve to suffer consequences for their actions. The ICC statute directs the court in determining sentence to take into account such factors as the gravity of the crime and the individual circumstances of the convicted person in accordance with the rules of procedure and evidence. The rules then provide much more detailed guidance, listing factors for consideration in sentencing that include the extent of the damage caused, the harm caused to the victims and their families, the nature of the unlawful behavior and the means used to commit the crime, the degree of participation of the convicted person, the degree of intent, the circumstances in which the crime was committed, and the background of the convicted person. The rules also suggest factors that might mitigate sentence, such as any effort the convicted person made to compensate victims or any cooperation with the court, and aggravating factors such as abuse of power or official capacity, particular cruelty, or a motive involving discrimination, for example, on grounds of religion or ethnicity. The factors are not exclusively, or exhaustively, I should say, not exhaustively listed. Sentencing generally tends to underscore the gravity of the conduct, especially its impact upon the victims and their families, the need to denounce such conduct, and the objective of deterring the individual and others. In domestic criminal cases, rehabilitation of the individual, that is, the susceptibility of the convicted person to successful reintegration into society, can be an important consideration. However, judges in sentencing for genocide, crimes against humanity, and war crimes, given the gravity of these crimes and their impact upon the victims and communities affected, tend to place little weight on rehabilitation as a sentencing objective. It's not, however, excluded, given the need to consider the personal circumstances of the convicted person and any amends he or she may have made. Generally speaking, nevertheless, the emphasis is upon retribution, that is, recognition of the suffering of the victims, public denunciation of the conduct, and individual and general deterrence. The goal is to contribute to the prevention of mass atrocity crimes. The notion of moral accountability finds expression in sentencing through examination of the form and degree of responsibility of the offender for the crime. Such consideration encompasses many factors, such as the power or influence of the offender, the zeal or cruelty with which he or she acted, and the specific role played by the offender. Trial chambers attempt to impose a sentence that is proportionate to the gravity of the offense and the degree of responsibility of the offender. The most severe penalty, which in international criminal law means life imprisonment, is reserved for the most serious offenders. Once again, there is little focus upon the workings of the brain at the level that may be the preoccupation of neuroscientists. To sum up on punishment, there's an effort to have the punishment suit the crime and the role played by the convicted person in its commission. A wide variety of factors come into play relating to the gravity of the crime and the particular circumstances of the offender. Denunciation and deterrence are the sentencing factors likely to receive most attention when a sanction is imposed. What relevance, then, may neuroscience have to international criminal justice? It may contribute to a more sophisticated appreciation of the factors at work in mass crimes, and these are important to understand. Some branches of medical science, such as forensic psychiatry, have become highly relevant to concepts of responsibility and treatment in criminal justice. Personally, I would be surprised, however, if considerations of syndrome E had much impact on the approach that international criminal justice takes to concepts of responsibility and perhaps even punishment, which the law applies to help deter the commission of war crimes, crimes against humanity, and genocide. Thank you.